Hey, it's still morning. Good morning, everybody. Thank you for joining us. I'm Neil Kalin. My co-host is Michael Simkin. We have a wonderful guest today, Gerald Serlin, who is an appellate. I guess I'm assuming you're an appellate specialist, right,
I'm an
Gerald?
appellate law specialist. That's right.
Yeah. Okay. Great. And so you're going to participate, and we're going to talk to you and interview, and you're going to tell us all about that stuff. We're going to get started in just about 1 minute. So thank you for joining us. Got some really good cases today. I don't know if we'll even make it through all of our cases today. We'll see. If not, we'll carry it over. Have a bunch of great cases for next month, too. And if we need to carry one over, we'll carry one over. No big deal, but thank you for joining us. I appreciate that, everybody. And Michael, I don't know if you noticed, but now that we started the webinar, you can see the attendees if you pull up
I
the,
I
the
see that. I'm impressed. More and more logging in.
okay. Well, that's what we like to see, of
That's
course.
why I wore my suit. You see, I had to dress up like a lawyer today.
Yeah, Michael is putting me to shame. We'll see. Maybe next week I'll come in a tank top or something, to really bring the level down. I don't know. I think we're good to go, Michael. We've got about half of the people who registered, so that's pretty good. And hopefully a few more will join us as we go along. Welcome to What's Up With Us. We took the month off in June, but Michael and I are back now and we're rip roaring and ready to go. What are we going to be talking about today? Well, we've got Bartel versus Chicago Title, CoStar versus commercial real estate. We have our interview with Gerald, who I just mentioned, the Ashagian case, which in my world is causing a lot of confusion and a lot of disruption. And if we have time, we'll get to Wang versus Paletta. We do always want to talk about our RPLS activities. This is one of the many benefits of real property law section. We want to tell you about the other ones as well. And before we get into the Bartel case, I do want to mention that this presentation is available to you for 1 hour of free self-study MCLE credit. I don't know how many self-study credits you're allowed to do, but you're going to be able to take advantage of this one. You will get a certificate within a few days after we do our presentation today, awarding you that 1 hour of self-study. And tell all your friends, because we are also giving away a gift certificate that will entitle one of our listeners to 1 hour of MCLA credit at the RPLS online library. I'm not really sure how to access that. So hopefully Brooke or Morgan, who's helping us out today, will be able to put that into the chat tab. Um, Here we go. Oh, look at this. So you know what? We can even announce who is getting the 1 hour gift certificate. Well, I should put on my glasses. Look like it is Fred Pardis. So Fred, congratulations. You're going to get, in addition to your 1 hour MCLE self-study certificate, you're going to get a gift certificate where you can go on to the CLA online library, go into the real property section, and pick, I guess, any course you want that's for 1 hour. So wonderful. Brooke, if you get a chance, maybe you could post that into the webinar chat, because we'd love to have our members go into the online library because there might be something there that they're interested in. And you never know when you could, use some extra credits. So that's it for my introductory remarks. Anything from you, Michael?
Okay, so these past webinars that we're doing, the What's Up webinars, those are also on YouTube. There's also a link on the CLA website, but if you want to see what we've talked about in the past, then there'll be a brief description of the cases. There might be something that you'll find helpful on YouTube.
Yeah. Oh, wonderful. Great. Thank you. And we're gonna have to look, because we did have some difficulty getting all of those past webinars up, but most of them are now. And then we'll kind of examine that and see if there's some way to figure out, to categorize them. I don't know if there is. I don't know if we have the staff capacity to even do that, but we'll look into that. Thank you, Michael. That's a good reminder. Good reminder. Thank you. So let's jump right in. And this first case is right up, this is for Michael, right? So we've got a we've got our summary. Well, I'm confusing it. You're going to want to really talk about the shaking case. But Michael, do you want to start talking about Bartel, or would you like me to talk about it?
Okay, I like you to talk about it because
Okay.
some of the procedural things are interesting, and I think Jerry could help us. And then I'll give you my insights about why this case happened and some other
Okay.
things.
Okay, that's exactly what we want. So, in an interesting case, Bartel versus Chicago Title, where a property owner is suing its title insurer, saying you had a duty to defend. You had a duty to defend. I tendered 2 times, actually multiple times, but on two, really 3 times. What? You know what? Let me go into the facts here first, and then I'll get more. I'll get more into what happened. So here we have a situation. Bartel owns property. It's a rural property. The neighbor is using this road that goes in the front of Bartel's property, right, near their house. And what is the neighbor using the road for? The neighbor is using the road for trucks that are going to and from the neighbor's marijuana cannabis farm. I have no idea. Maybe one of the two of you noticed whether it was a legal grow farm or not. I don't know. But that's what the neighbor was using the road for. Bartel did not like this. Bartel really basically moved out into this rural area, wanted nice peace and quiet, did not want trucks going back and forth. All right. Warned its neighbor, stop using the road. The neighbor twice sued Bartel. The neighbor said, I have a prescriptive easement to use this road, or I have some other type of easement claim to use this road. But in the neighbor's complaint, the neighbor never said, I have a recorded easement right to use this road. For whatever reason, both times that the neighbor filed suit, both times Bartel tendered to the insurance company, both times the insurance company denied. Now, to the insurance company's credit, they did investigate what was going on here. Where is the road? There is an exclusion, of course, in a title policy for items that were not on title. The neighbor was claiming basically a prescriptive right, which is not a title right. There was also another exclusion for a road maintenance agreement. It was apparently difficult to figure out what road was this maintenance agreement talking about. As an attachment to these complaints, however, there was a reference to a 1971 easement, which turns out was different from the 1970 road maintenance agreement, which was excluded from coverage. Eventually, what happened, Bartel wound up suing the neighbor to try to get the neighbor to stop using that road. Again, Bartel tendered. This time, after the neighbor filed a cross complaint, the title company says, okay, we will defend. We're not necessarily going to say that we're going to indemnify, but we will defend, but only starting with this point at this point forward. We're not agreeing that we had any obligation for any of the two prior suits. The two prior suits, Bartel was expending their own funds in defending those claims. Again, both of them were ultimately dismissed. With Bartel's suit, what happens? The trial court reached a decision, basically said, you know what, there's an easement right. So the neighbor has the right to use this road, but there's limitations on the neighbor's right to use this road. Bartel, of course, was out of pocket a lot of money for all of those defense costs for the two suits, and in between, wound up bringing a claim against the title company for what? For breach of contract, bad faith, failure to defend, and Bartel was seeking punitive damages. The trial court in this suit said, well, guess what? Chicago did have a duty to defend as of the very first lawsuits that were filed by the neighbor, but Chicago Title did not act in bad faith and there was no punitive damages. Why did the trial court say Chicago Title did not act in bad faith? Because they did do some investigation into these various roads and the easements and the road maintenance agreement and the like. Bartel appealed. The appellate court affirmed that there was a duty to defend. The appellate court said, once the exhibit to that original lawsuit made reference to this 1971 easement, that should have put Chicago Title on notice that there's a possibility of coverage. Maybe so, maybe not, but that possibility triggered the duty to defend. The appellate court also said, you know what, there was bad faith here on the part of the title company. There was multiple request after request after request. And the title company, they're the ones who have expertise. When they saw that recorded easement, that should have triggered in the title company's minds, right, that there was a duty to defend. The title company kept going back, well, the complaint did not allege that there was a recorded right. And the court said that doesn't matter. We're talking about a duty to defend. So once there's the mere possibility that a duty to defend can arise, you need to step up and you need to take action. But the appellate court said, you know what? Chicago Title did do some efforts. They were not acting in bad faith. They were not acting with malice or oppression. They did not willfully disregard the interest of the insured. So the appellate court denied punitive damages. Michael, before you go in, I'm gonna just make one additional comment here, which is this is a very long opinion. And when it was originally written, it was not for publication. And the party, Bartel's lawyer, an outside lawyer, submitted a request for publication. The company that I work for, the California Association of Realtors, we think it's important that property owners are able to rely on their insurance companies in this instance. So CAR also filed a request for publication, and lo and behold, the day after CAR filed its request for publication, the court ordered the case published. Michael, tell us about this case.
Wow, CAR has a lot of power. That's it.
Right. It could have been coincidence, but I like that coincidence.
Although on another case, he didn't get that power. But anyway, okay. Okay, so I'll tell you what I like about this case. And then there's some technical issues that are kind of interesting. But this case, I completely agree with the opinion. I'm not, even though I used to work insurance defense a long, long time ago, insurance company is in it to collect the premiums and not to pay out. And they play this game and they play with you as much as you can. And then they usually give in, which is kind of like what they did here. But this case, I'm glad it goes through the approach. Insurance goes to claims, not lawsuits. So when Chicago Title was saying, well, there's no pending lawsuit or something, no, it goes about the claim. That's what they have to do. Um, this case is also essentially about legal fees. And it's also kind of interesting because the insured, basically lost the case, but then he kind of like wanted to get back his legal fees. Another huge thing that I see coming up over and over when I'm tendering, because I tender everything. That's really important for attorneys to do. They don't realize where there might be coverage. There might be coverage under a title policy. There might be coverage under an umbrella policy. There's like a lot of things, okay? But you also have to look at the extrinsic facts because some plaintiffs, I always call, I shouldn't say this, but I tend to call up plaintiffs' lawyers and say, are you sure you don't want to amend this? Because you could easily get coverage here because you have some facts here that are just made up and wrong. But if you kind of like add the facts that really happened, I probably can get you coverage and then you have a pot of money. And the insurance company also has to look at extrinsic facts. So if the complaint is like one of these bare bones form complaints that says nothing, but you happen to have a letter from the plaintiff saying you did all these things, or you didn't tell me about this, or your prior owner didn't do whatever, bring that up to the insurance company, try to get coverage. Because that's what this case is about. You want insurance for the costs of the legal costs. That's the whole point. Okay, now you mentioned about there's 1970 and 1971 agreements, the other easement agreements. So I found it interesting that there's a road maintenance agreement, which I think I mean, is that different than a road ingress and egress agreement? I don't know. You're going to have force someone to pay to maintain it, but they can't use it. So I kind of think that means use it. What do you think, Neil?
Of course, I did not look at the actual road maintenance agreement, but it seemed to me that there would be both, right? That you would not have the need for a road maintenance agreement if there was not an otherwise right to use the easement in the first place.
Yeah, so that's like an important fact for determining if there's coverage, right? If it's excluded. Um, but this case was essentially about, I think, equitable tolling. Okay, and they cited the Supreme Court case that, it's not fair for someone to have to defend the case and then you deal with the insurance. So I'm glad they had that discussion about equitable tolling and they found that in favor of um, the property owner or the insured. I also found it interesting when it got to this bad faith part, this confidential memo from Chicago Title that it had a duty to defend. So did they get that as part of discovery? They didn't really talk about that confidential memo because that was kind of interesting because the Court of Appeal clearly used that in forming their opinion. Um, but this is a case that you can win, but you can lose, I guess, at the same time. That's
Well,
my substantive analysis.
I, I think you're right, and I think the party who brought the suit, Bartell, the property owner, I was speaking with the spouse, and a very emotional case. They felt very strongly about pursuing this. They were very disappointed that originally the case was ordered not to be published. And because they put years and years and years into this, a lot of money into this. This is going to be, their idyllic spot where they would be, free from the noises of a more urban or suburban environment. And they didn't. They wound up not getting that, where they were. So and that plays into this as well. Gerald, do you have insights on this case?
The insights I have in some respect are rather mundane with regard to the duty to defend. As everybody can see when they read the opinion, it's a very standard presentation with regard to the duty to defend, and that it's broader than the duty to indemnify, and that, the insurance company is required to look at all facts, both disputed and undisputed, anything that it becomes aware of to assess whether at the time of tender there is a duty to defend. And here, not surprisingly, the insurance company, and I share the views that insurance companies sometimes don't step up to the plate immediately, did have a duty to defend and not necessarily a duty to indemnify, which was really the focus of the insurance related question. Um, but what I found to be, or at least the primary insurance related question, but the part of the opinion that actually really caught my attention was the bad faith determination. The trial court had made a determination that there was no bad faith here, and in fact did so because this was such a complicated and convoluted case that said, well, the insurance company didn't really know how to handle this, and so the denial wasn't in bad faith. But the Court of Appeal took a different view of it and said, no, this actually was bad faith. So what the Court of Appeal did is make a factual determination, which is typically ascribed to the trier of fact. And the Court of Appeal said, no, here on these facts, we are going to make a finding as a matter of law. And so under the circumstances here, this is in appellate wonky language, this is called a failure of proof. The trier of fact found that there was the cause of action wasn't sustained by the plaintiff at trial. And here the Court of Appeal reversed it and said, no, in fact, there is bad faith as a matter of law. And you very, very seldom see that. That's really a remarkable finding by an appellate court. And so in its own way, this is a good case to know, because you see that appellate courts sometimes will look at the evidence that's come in and say, no, as a matter of law, this was bad faith. And there was no evidence really that could support a contrary view.
Now that was great insight. Thank you, Gerald. Really, really appreciate that. The other thing I just want to mention is, if you read this case and you read the citations, you're not going to see very many citations to title insurance cases, right? There's citations to all sorts of insurance cases, practically nothing. I don't, maybe there was one citation to a title insurance case. You do not see a lot of title insurance appellate opinions out there in California.
Right, Neil, I have a question. Do you know if this was a legal or illegal cannabis farm?
I don't know. I don't know.
Okay. I don't know, that makes a difference. I mean, I see the picture of the truck. I figure that's a lot.
Hey, I just try to, do something to catch people's eye, because I know they don't want to look at our talking heads. All right, so let's move on to our next case. And I think we're just gonna, I don't know, I'm not gonna go into too much detail in this case. It involves two competing commercial real estate listing services. CoStar, which maybe most people are familiar with, LoopNet, first brings a lawsuit against a competitor, commercial real estate exchange, saying, wait a minute, you've taken our information, you've misappropriated it, we have copyright protection in that information. So commercial said, well, we're going to defend against those claims, but we're going to bring claims against you. We're going to file counterclaims against you for antitrust concerns. You're a monopoly. And you enter into all these, what in our view are exclusive agreements with brokerage companies, commercial brokerage companies, to list their property on LoopNet. So CoStar brought a motion to dismiss the counterclaim, the antitrust counterclaim, and the trial court granted CoStar's motion and said, well, C-Rex, commercial, you failed to show through direct or indirect evidence that there's monopoly power. And, I'm going to pull up something on my other screen. Give me just a second here, folks. See if I can find it. So it was interesting in the opinion. There's a section in the opinion where they talk about courts generally require a 65% market share to establish a prima facie case of market power. Here, C-Rex alleges that CoStar has a 90% share of the listing market, a 90% share of the information market, and a 95% share of the auction services market. And I don't know, we'll let Michael and Gerald talk about that, a little bit later on. And so anyways, the trial court granted CoStar's motion. C-Rex obviously didn't like that. They appealed. The appellate court reversed. The appellate court said, well, C-Rex at least plausibly alleged that there's market power. And given what I just read, we'll let the other two comment on that. And interesting, there's also an argument about exclusive agreements, and the agreements that CoStar has with the commercial brokerage companies do not say that they're exclusive, but commercial real estate said, well, you don't say they're exclusive, but everything that you have in those agreements effectively makes them exclusive. So the fact that you say they're not exclusive doesn't matter. They are de facto exclusive. And that's all I'm going to say about it. Michael or Gerald, what are your thoughts of this case?
Well, so this motion to dismiss, the court still said that CREGs has to prove their damages and their allegations in court. Okay, and the one thing that I was fascinated about, besides a nice little summary of the law of antitrust, which I liked, I never knew, it seems to me that there are these, I like where it said the technological barriers were problematic. And it seems like the court was really fascinated about that. So I don't know how this works with LoopNet and CoStar, um, but it seems that the issue was C-Rex wanted to scrape the LoopNet website to get broker information, and there was some sort of technological barrier to prevent C-Rex from scraping the site to get the broker information and the listings under the broker. And I don't see what's wrong with that, because I know that scraping websites is a big deal. Like, there are companies that scrape websites just to like check out the competition so they can like have the prices lower or whatever. So I don't see what's wrong with CoStar putting some like anti-copy technology. And I mean, was that your understanding of this, Neil?
I was looking at that from a little different perspective. A lot of that was quite honestly a little confusing to me, but I think part of it had to do with in order to make the commercial real estate listings eligible for LoopNet or through CoStar, they had to use a certain system. And so it was not necessarily just the scraping, it was the way they had their data, that data could not be usable by a competitor. So I think that was an issue as well, not just a scraping issue.
Mhm. All right. But I don't know, procedurally, what do you think, Jerry? I, I don't see anything
You
procedural
know,
here at all.
procedurally, I thought this case was sort of, it illustrates a nice distinction between state court and federal court practice, because as we'll see later in the Eshigian case, here, this case, the case wasn't over. Only certain causes of action got eliminated by the federal district court. And then the federal district court, pursuant to Federal Rule of Civil Procedure 54, then certified the matter for appeal. And the district court said, well, this isn't going to be really a piecemeal appeal, because all of the issues that are going up on antitrust are legally severable from the other issues at hand. And so we're going to hear just the appeal immediately. And that's not typical, at least in state court practice. And I suspect it's not even typical in federal practice. Again, I think this is probably an outlier case where you get to see an immediate appeal arising. And so from my perspective, that was kind of interesting.
And from my
So,
perspective, that's why you settle cases, because courts of appeal can go either way and you just never know.
Because
but
at the
before we
bottom,
started, Michael asked me, and I'm going to get back to the procedure with you, Gerald, in just a minute. Michael asked me, how does this pretend for non-commercial listings, for residential listing services? And there's multiple listing services. Most of them cover certain geographic areas, but several of them are regional, and there's attempts for some to try to even create a statewide multiple listing service. But really, to me, the more direct competition for these multiple listing services is the other portals. So you've got like a Zillow portal, or you have brokerage companies that have their own portal, like Redfin. You've got these other portals that are not really multiple listing services, because they're not agreements among or between real estate licensees to share that information. So there's not a direct correlation, I think, between the CoStar situation and what you find in most residential real estate listing type arrangements. Sorry, Gerald, I cut you off.
no, and I'm just going to go back to the original aspect of the appeal. I mean, again, this just struck me as almost just a straight out pleading type question. Did they allege sufficiently, whether CoStar had sufficient market power to preclude other companies from entering into the field? And the quick answer was yes, for the reasons that you were outlining before, saying 90% shares of markets. And it just resulted in the case being reinstated. Obviously, there was no determination as to whether there'd be liability or anything beyond that. But I did find the right to engage in the immediate appeal interesting. And to Michael's point, yes, with that determination, that may prompt an early resolution of the case. But they've wound up with an adverse circuit court opinion saying, yeah, you have alleged sufficient market power to at least get past a pleading question.
Yeah, decades ago, motions to dismiss, I used to file them like decades ago, but I would never do one today. It's just, I don't think it'll be granted.
Well, then again, the trial court almost looked like it made a finding of fact that sort of seemed to be in contrast to the allegations about the percentage of market share, right? But this didn't really seem to be a case to be making a decision of fact when you're at a motion to dismiss as opposed to a motion for summary judgment. But you two are the experts in that. I'm not. And now that we're talking about experts, well, great. We're going to talk to the expert himself. We're going to talk to Gerald. So in addition to opining on our cases and giving all of you some great information, we're going to learn a little bit about Gerald and his practice. And Michael, maybe you have some specific questions for Gerald. If not, we'll just have him start and tell us, what is it that you do and why is what you do unique?
Go ahead, Jerry.
Okay. Well, as everyone's probably gathered by now, my name's Jerry Serlin. I'm a certified appellate law specialist and a principal of Benedon and Serlin. We're a 9-attorney appellate law firm, and we're somewhat unique in the world because we tend to represent more plaintiffs than defendants. We typically do not represent the big entity over the small guy. We tend to represent the small guys. We've been around since 1993 and have been fortunate to be well recognized by the legal community. And we've also had some fairly interesting cases that have gone before both the U.S. Supreme Court and the California Supreme Court. So we've had a good run so far. What can I tell you?
Well, I have a question. So from a litigator's point of view, when should a lawyer consider consulting with an appellate attorney?
That's an excellent question. And the answer is typically before you get to a point where the matter is going up to the Court of Appeal. Our firm has been brought in at summary judgment stages, at pre-trial stages where the matters are being prepared for trial. Recently, I was helping to craft special verdicts because you want to make sure that they're very straightforward, readable, and you don't sow appellate error into the verdicts that you create. You don't want to be accused of at least feeding ammunition to the opposing party. And so we've been brought in on many occasions to help guide trial counsel because we're apt to do the legal research that trial counsel no longer have the time to engage in.
Okay. And when you look at a case, I have an opinion, and I expressed this to you the other day. There are litigators, there are transactional attorneys, and say appellate attorneys. And everybody has a different way of looking at, the set of problems that, their approach to solve. How does an appellate attorney approach an issue?
I guess it all depends on, what the procedural posture of the matter is. If one party has won and one party has lost, it's going to guide tremendously how you address the legal issue. And are we going to be representing the party that lost? And what this devolves down to is typically questions regarding what is the standard of review. If it's an evidentiary question, very often you're looking at whether there's substantial evidence supporting the trial court's or the jury's determination. If it's on a motion, you're going to be looking at an abuse of discretion type standard. If it's just a straight out legal interpretation, for example, like the interpretation of an insurance contract, as we were addressing in the Bartell Chicago title case, or a contract, or just other straight up legal matters that arise. Those are going to be reviewed de novo. And so depending upon the hat we're wearing in any given case, it's going to sort of largely define the approach we take in terms of addressing the legal matters.
Will you ever take a case that you think it's very tenuous if whether or not you can get a reversal or sustain it? I mean, do you look at the merits of the case before you accept it?
Our firm does. I mean, we do a preliminary evaluation to make sure that there's at least a potentially meritorious issue before the Court of Appeal, because nobody wants to be whacked by the court for filing a frivolous appeal. But do we take cases that are close to the edge? Yes, sometimes we do. And let me start with, we've never been told that an appeal we filed has been frivolous, period. Never happened. But we've had motions sometimes filed, and we handled one case some years ago where we filed the appeal, the other side filed a motion arguing that our appeal was frivolous, but we actually got a reversal. And so the Court of Appeal said, we understand the arguments being raised by the respondent, but we typically don't sanction appellate firms for winning their appeals. And so we squeaked by on that one. And it is, whether a matter is frivolous is defined both by a subjective and objective test as to whether the matter is frivolous. And we've never fortunately tripped over that line.
And at the appellate level, I have two questions. One,
Sure.
if someone did file a motion to try to have the court determine it's frivolous, I'm guessing that determination is reserved for the opinion. Is that correct?
It's reserved for the appellate panel. And if a motion is made to argue that your appeal is frivolous, the Court of Appeal can direct you then to respond, or can just sit back and wait to see how things progress. Typically, if you're not asked to immediately respond to the motion, that means the Court of Appeal does not see the matter as potentially frivolous.
And can the person making that motion be sanctioned?
I've never seen that done. I suspect the motion will just be blithely ignored and moved on.
And do the Court of Appeals have a mediation program that parties can use?
And that's also a very, very valuable tool. At the outset of every appeal in which we're the appellant, and sometimes even the respondent or the appellee, we do reach out to the other side to see if the matter can be resolved through settlement. This year alone, we've settled probably on the order of 5 or 6 of the cases in which we've been hired to act as counsel for the appellant. And that's unusual. We usually don't settle that many cases.
Whoops, we got frozen there.
He got frozen there. So while we're waiting for Gerald to unfreeze himself,
Losing. Yeah.
there we go. He's back. He's back. Go ahead.
You got frozen for a second. So you said that 5 or 6 cases you've been able to settle while it's being appeal, which is unusual in your appellants. And this is a program set up through the local Court of Appeal?
Both the state courts of appeal have their settlement programs, and the federal circuit, the Ninth Circuit, has a settlement program as well. And in the Ninth Circuit, in virtually every case, they require both parties to participate in an assessment conference. In the state court, both parties have to agree to participate. And so it's a very valuable tool, often overlooked.
Okay.
Hey, Gerald, I've got a question for you. Before I do that, I don't think Michael knew this when Michael's the one who proposed and obtained Gerald to speak with us today. But the company that I work for, the Association of Realtors, we've actually used your firm, Benedon and Serling, a couple of times over the years. Most of the time, CAR internally drafts its own amicus briefs. Sometimes we need to go out. We have had the opportunity to use your firm a couple of times. My question for you, I think it's the last question, we're gonna have to get to our next case, is there a different philosophical approach when you are involved in a case that's on appeal before the Court of Appeal versus a case that's been granted review by the Supreme Court, California Supreme Court?
The quick answer is yes, because in the Court of Appeal, it's largely going to be decided by stare decisis, what other courts have done. And once you're before the Supreme Court, the field opens up. We've had cases where we've overturned precedent that's existed for literally hundreds of years. I grant you this arose in a trusts and estates matter, but we were involved in a case by the name of Estate of Duke. And we changed the law. We were part of a team that changed the law that had been in existence for 200-300 years. That was a great victory for our clients. And but we've had other situations, and I had mentioned this to Michael just yesterday, where we were before the California Supreme Court and we thought we were playing a winning hand because there were 2, 3, 4 Supreme Court decisions that favored the arguments we were raising. And so what happened? Well, the Supreme Court then depublished or overturned their own decisions and then ruled against our client.
Oh.
So the field is much broader in the Supreme Court than it is at the Court of Appeal. And not only can you simply just rely on Supreme Court precedent, you have to establish why that Supreme Court precedent may still be viable when it is challenged by the other side.
Well, thank you, Gerald. Hopefully you can stay with us for the remainder, the 20 minutes that we have left in our presentation today. As I mentioned, we're only going to be able to get to one more case. Anyone who wants to contact Benedon and Serlin, the information is on your screen, and everybody will be sent, all the listeners today will be sent a copy of the PowerPoint presentation. So if you miss it right now, you'll be able to get it in your inbox later. So let's talk about Ashagian versus Cepeda, a case that really has two arms to it, and each arm has their own important steps. There's a procedural element to this, which is what happened in this case. A landlord served a tenant with a 3-day notice to pay or quit. Then I don't understand exactly what was going on here, but after the tenant did not pay, the landlord filed an unlawful detainer. The landlord then brought a motion, a discovery motion, and the tenant did not respond to the discovery motion. So then the landlord moved for a default, saying, well, wait, they didn't respond to the discovery motion, therefore their answer should be stricken. If there's no answer, I'm entitled to a default on the unlawful detainer. And the landlord obtained the default for possession only. In the unlawful detainer, the landlord asked for possession and damages. The default was for possession only. And then the tenant decided to contest the default judgment, and there was an issue which is how do they contest it? Do they contest that through the appeal process, or do they have to contest that through filing a, I guess a writ would be the right term, okay? And what happened there? Well, this was to start off at the minimum jurisdiction case at trial, and so it went up to the appellate division of the Superior Court. And the appellate division of the Superior Court, what did they say? They said, well, there was not a final judgment because the request was for both possession and damages. There was not a final judgment. The only way to contest this is through a writ, not through an appeal. And the appellate division also addressed the substantive issue that the tenant was contesting, saying there was a faulty 3-day notice to quit. And the appellate division agreed that there was a faulty 3-day notice to quit, and we can get into those a little bit later. But first, why don't we just deal with the procedural aspects of this, Michael and Gerald?
All right. So
So
look,
after that, I'm sorry, after the appellate division of the Superior Court made their decision, the appellate district court said, you know what, we think this is an important issue. We're going to take this case up on our own. I don't know how often that happens, but they
Never.
decided to take this case up on their own and issued an opinion. Go ahead.
But I also just want to step in for one brief moment. I think as your squib on the case says, the appellate division held that it was appealable, even though it was only a partial judgment. The appellate division said, well, it's a judgment for possession, so we're going to treat it as a judgment, and then address the question as to whether the 3-day notice was correct or incorrect.
Thank you for correcting my error. I was confusing my appellate division with my appellate district. Thank you.
but you know what else? The timing between the two. The appellate department made their ruling and they published it, I believe.
They did.
Within a month or less, on its own motion, the Court of Appeal took it up.
That's required. That it has to be addressed rather quickly. Otherwise, it never would have been addressed.
Yeah,
So Joe, what would have happened here? Did one of the parties have to make a request to the Court of Appeal? And how does the appellate court decide we're going to just take a case up?
Let me just confess my ignorance on this general topic. I mean,
Okay.
because typically these sorts of appeals, I mean, I don't know if you'll recall the values that were at issue in this particular matter, but they were on the order of $8,000 for back rent or something,
Right.
very, very low dollar values. And so our firm typically will not get involved in matters like this just because it's not cost effective. But my vague understanding is this, that once the as you correctly said, the matter was heard in limited jurisdiction court in the Superior Court, went up to the appellate department of the Superior Court for review by a panel of 3 justices. And that's where they made the determination that this was appealable, but the 3-day notice was defective and reversed. When that adverse decision came out, my suspicion is that Ashigian, the landlord, would have then written up some sort of a document which tees up the matter for potential appellate court review. The appellate court will review the matter and then said, for purposes of consistency, we are going to take this case on our own. And that's the point where there was appellate briefing in the Court of Appeal. I hope I haven't bollocksed this up, but that's my vague understanding as to what happened.
No more than Michael and I normally would do so don't worry about that at all.
we bollocks all the time.
Well, I'm glad I'm in good company then.
I realized we only have a short time left. I forgot to remind our audience today that if you go into the Q&A tab, if you've got a question for us or our guest or if you just want to opine, you can do so in the Q&A tab. You know, here I am saying this 50 minutes into our 1 hour presentation. I forgot all about it, but I see there's nothing in that tab. So obviously, because I forgot to mention it. So anyway, so the case went up, the appellate court took it. The appellate court said, well, guess what? It really was not appealable, but we're going to treat the the tenant's appeal as if it were a motion because we want to hear this case
As a
and we
writ
think that's the
petition.
right way, and we've got unique circumstances here. Tell me what I've got wrong in that last statement.
You basically had it right, but the Court of
Okay.
Appeal then treated the appeal as a writ petition so that they could review it immediately. And again, that's fairly unusual. There's some sort of a 5-factor test which is employed by the Court of Appeal as to whether you can treat an appeal as a writ petition. And the court found that here the balance of the factors had been achieved, and so the court actually then chose to hear the matter
Okay.
and treat it as a writ
Thank you. So
petition.
good. So now I'm going to skip to the substance here,
Yeah.
which is, was the notice that the landlord gave to the tenant, the 3-day notice originally, was that a defective notice? And both the appellate division and the Court of Appeal both came to the same conclusion, but the Court of Appeal went beyond what the appellate division of the Superior Court said. And so they looked at the 3-day notice to pay or quit that the landlord provided to the tenant. I've seen this. It was an attachment. It was an exhibit to the complaint. It was not any of the standard form 3-day notices. I don't know if it was attorney created or if the landlord drafted it on his own. I suspect the latter more than the former, but I really have no idea. And the appellate court looked at this and said, well, there's a few things, you know, that were wrong with the notice that was used. So first of all, for where the tenant had to pay, they listed the tenant's address. And they said, you need to pay the landlord at the tenant's address. And they gave hours between 8 a.m. and 9 p.m. Well, what is the landlord sitting there at the tenant's address all day and all night, waiting for the tenant, you know, to give them payment, you know, just sitting there for three days? So something clearly, you know, was wrong there. The next issue was the court said, well, the notice did not tell the tenant that you might lose possession if you don't pay on time, right? So the notice said 3-day notice to pay or quit. It did not say pay rent or quit. It just said pay or quit. It did not mention anything about the landlord seeking the right to possession of the property if rent was not paid. So he said that's another defect. And then the third defect that they talk about was there was no starting point. The notice that the landlord gave was dated, but we don't know what that date meant. Was that the date that the landlord signed? Was that the date that it was served? How was the tenant supposed to figure out when the 3 days begins and when the 3 days ends? And that part of the opinion has really caused consternation in the unlawful detainer and the landlord tenant field, because I would say it's unclear as to what the holding is. Is the holding of this opinion that you have to identify a specific date that the 3-day period begins, that you have to identify a specific date that the 3-day period ends, that you have to identify both? Can you just refer to the date of service as when the 3-day notice starts, which is how the statute reads? And it's become quite problematic because,
that's the key. The statute, 1161 paragraph 2, state the
yeah,
amount
go
of
ahead.
rent, then due. That's what's needed.
Say that again, Michael.
You need to state the precise amount of rent, then due. That's CCP 1161 paragraph 2,
Yeah.
right?
Okay.
And so I wish that the Court of Appeal would have attached the image of that special 3-day notice that was done so people can see exactly what not to do. I mean, they described it, but that's easy. The one that I think is more interesting is I don't know how this guy phrased the part about that the landlord would repossess the premises if the rent was not paid. I'd like to see how it was phrased. That's what they should have put in there. What's wrong, because most Filipinos do say something along the lines of, you will go seeking possession. There's something in there.
Right, right. We will seek possession and damages if you're asking for damages, if you're asking for an amount as well. So again, the standard form type notices probably sufficient, but maybe not. There's there's big consternation in the industry as to what now needs to be done, whether any notice that was filed prior to this opinion is now subject to attack because of this opinion. And if the notices that were given are defective according to this opinion, what would need to be done to correct those notices, either for existing cases or moving forward? I've seen some people suggest you have to have a starting date and an ending date. Well,
Yeah, but that's not in the statute. See, that one I disagree with. They can't say, because so this is the problem with the start and the end date deal. This is historical. It's say they used to have in the 3-day notice to put rent due from blank to blank. So say you have more than 1 month. You have like April through November. There used to be a problem, especially with I think it's Civil Code 1479, which I call the designated rent offense, where the tenant, say, in between the period of time, like they stopped paying in April, but they made a partial payment in July, another partial payment. But when you have this range, then you have a little bit of a problem because they made some payments during that range. So the statute says state the amount of rent then due when the 3-day notice was served. So then they kind of changed these forms and they just said the amount of rent due, and you put the date like April 1 or whatever. That's all you have to do. And that's still consistent with this opinion.
well, see, what I think is troublesome about this opinion is not the amount, but when the payment has to be made so that you can say you satisfied the the payment, and therefore you can prevent an unlawful detainer from being started in the first place.
Well, then
And
that's the
to me,
language of
that
the notice. That's how you have to say, you must, pay the rent or surrender the premises to the landlord within 3 days after service of this notice.
well, and if that was how the Court of Appeal left this, which was essentially what the appellate division said, but that's not what the Court of Appeal said. The Court of Appeal pointed out defects, saying there was no starting date or ending date. Well, so that's what's caused disruption in the industry, which is, well, how do you have an ending? What if you're serving by mail because you can't serve in person or by substituted service? How can you say when that ending date is going to be because you don't know when it's going to be delivered? That's just one example. So there's a lot of interest in this case, on both the landlord side and on the tenant side, right? I can tell you that at least as of yesterday, there were already 3 requests to depublish this opinion. Getting depublication is not an easy thing to do, but
Yeah.
there have been requests, and from my reading of the rules of court, there's 10 days to respond from the first request for depublication, and that 10 days ends on Sunday. So I don't know if courts carry over to a Monday or not.
Yes, yeah.
So they're, and whether, and requests for depublication go to the Supreme Court. How they make those decisions is not something that's within my purview. Maybe Gerald has some thoughts on that.
You actually stand a chance. I mean, if you show how the appellate decision is inconsistent with the statute, you may be able to get a depub by the Cal Supreme Court.
Well, I guess we'll find out. We're brushing right up at the end of our time today. So we're not going to discuss that last case. once again, we'd love to have you get involved with the real property law section. Multiple ways to do that. You could write articles for our monthly newsletter, write a long article like a law review type article for our journal. You can get involved in one of our committees. There was just earlier this week, there was a webinar on buying property in Spain. There's one coming up at the end of this month. Everything that you want to know about broker law. I know the speaker. He knows everything there is to know about broker law. I don't know how on earth he's going to do that in an hour, but might be worth attending because I don't think there's anybody who knows more about real estate broker law than the speaker for that case.
That's
And
Fred,
then
right? Fred?
that's Fred Trester, yeah. And then our newest committee, which is the International Real Property Committee of the Real Property section, is going to talk about basically real estate in Dubai. Next month, we're scheduled for, we do this on the third Thursday, so that's August 21st. So hopefully Michael and I won't have a conflict. That's when you'll see us. Thank you for joining us. Congratulations, Fred, on getting 1 hour of free MCLE for the online library. And again, everybody look forward. You'll get your 1 hour self-study certificate, I suppose, in the next few days. And we've got a whole bunch of great cases to discuss next month as well. The one we didn't get to today, and there's some other good cases that I already have pegged up. So we hope you join us again next month. Gerald Serlin, thank you so much for being our guest. Great contributions. I was so happy that you joined us today.
Appreciate the invitation.
All right. Thank you,
Michael,
Jerry.
take us away.
Take care, guys.
Well, thank you.
Thank you, everybody.
Thank you. See you next month.
Bye.
Bye.